The question is the adoption. Senator Foster.
Thank you, Madam Chair. I'm sorry, but I do have to make this point, and that is, look, we're basing this on a public safety model versus the medical model. If we were basing this on the medical model, there would be a lot of changes that I would suggest we put into this bill. And hopefully that can happen during some of the rules that will come from, working with the Department of Revenue and the Department of Health and Human Services, and can establish, as we go on, some really good basic rules, because that'll be a good, fine medical model. We're not dealing, unfortunately, with the medical model. We're dealing with a public safety model here. I think that when you start asking people to have SSI and showing SSI, then you're going to have to, it will be so complicated. And I think that you're opening up a can of worms right now that, quite frankly, we can't address until you put the rules into the into this plan. I would really, as much as I agree with Senator Penry that something should be done, we're not dealing with the medical piece. So I'm really sorry for right now. Sorry.
Senator Penry.
Yeah, thank you, Madam Chair. Senator Foster's speech was so moving, I'm going to withdraw the amendment and come back with another one.
Okay. Amendment 168 is withdrawn. Mr. McGowan, please read Amendment 169.
Amendment 169 to House Bill 1284 by Senator Penry. Amendment Rico, Bill page 60.
Thank you, Madam Chair. I'd move Amendment 169. Senator Renfro actually raised this issue as we were talking about it within our caucus, about what the implications are if you're you own a business and you're in the heavy equipment business, and you have an individual who's driving heavy equipment under the influence of medical marijuana. The point is whether it's a legitimate medicinal application for the person or not is immaterial to the question of whether or not that person should be driving a heavy haul truck while under the influence. So what this language articulates is that this legislation, to the extent we're blessing the constitutional amendment and creating a framework for regulation, does not affect an employer's ability to say, you know what, if you're using marijuana and driving our heavy haul tractor or a truck at the same time, you can't do that, and we're going to terminate it. Ultimately, it still retains the authority of employers to regulate their employees in this respect. I don't think the bill oversteps this, but I think it's an important clarification because we've heard it from some employers.
Senator Carroll.
In the Constitution, there's no employment right. It's already in the Constitution.
Thank you, Madam Chair. Members, I oppose this amendment. Part of what was talked about isn't in the amendment, so I just want to be clear that for someone who's driving under the influence, even now on a prescription drug, that does not give you a pass on a DWAI or a DUI or any other standards that would deal with the operation of heavy equipment. But what this is permission to do what would be wrongful termination against a lawfully disabled person who has a card. And there are other people at work who may be on OxyContin, on a variety of other drugs with side effects that aren't per se invited to termination from their jobs. So this is saying a public or private employer may terminate an employee for testing positive. First of all, it's going to be in your system. So what you're saying, and it's true, if they're disabled, maybe they don't have a job. But there is a segment of people with disabilities that are working with disabilities that I know Senator Foster has helped try to place people with disabilities in work, and this would be a per se right to fire those folks. I just think that's not good public policy, and hope we will defeat this amendment.
Senator Spence.
Thank you, Madam Chair. I ask for a no vote on this as well. Members, this bill doesn't address lots of things that we need answers to. Employment law is certainly one. There are legal issues. There are banking and loan issues. There's insurance coverage. There are lots of things that can't be covered in this 50 or 70-page bill, whatever it is. But, you know, we have a start, and as we move forward with this legislation and this regulation, at some point, probably next year, we could come back and address some of these issues, but there are so many complexities that just don't fit within the parameters of 1284, so I'd ask for a no vote.
Question is the adoption of Amendment 169. All those in favor say aye. Opposed, no.
No.
The amendment's lost. Mr. McGowan, please read floor amendment 170.
Amendment 170, House Bill 1284 by Senator Johnston, amend Regos Bill.
Johnston.
Madam Chair.
Thank you, Madam Chair. I move Amendment 170. Members, what this amendment does is the same amendment we discussed when we debated 109 several months ago that I offered, which is this is simply a protection to make sure that there is not marijuana that is used or carried onto school campuses. We've talked to some principals and teachers right now who have 18-year-olds who have medical marijuana cards who will bring marijuana onto campus, and if a principal stops them or seizes them, there is no way for them to have any consequence for that, given that they have a right to carry it. Given that there's no ability for them to publicly consume it, it's not like they would be able to be taking that medication at school. For the 24 or so people under the age of 18 that currently have cards that have gone through that robust process, there would be ways for them to work with their doctor to have them take prescriptions in the morning before they come in or after the school day is over. I think for us to require them to be carrying it on campuses and to have school nurses now in charge of dispensing them, as you know, any child that takes medication out of school, the nurse and the school is required to be in custody of that medication all day long and to dispense it to the students. Students can't self-medicate while they're at school. And so if a student that had this medication were to come to school, it would have to now be going into school custody, possessed by the nurse, distributed by the nurse, which creates all sorts of problems when you still have a federal and state Drug and Free Schools Act that ought to prohibit that, not to mention have nurses being able to dispense it. So I think this is just a reasonable accommodation to make sure our schools can cut down on the recreational use of this and to make sure the handful of young people who have real medical needs for it are getting prescriptions that help them work around taking it during the school day. I'd ask for an aye vote.
High school or preschool?
Senator Romer.
Yes, Senator Johnson, I actually support this, but I want to be clear. So, Senator Johnson, if you want to, I want to come and make sure you're tying this to the same definition that I'm tying it to, which is on page 715. School means a public or private preschool or public or private elementary, middle, junior high, or high school. And therefore, you're referring it just to that definition of school, which does not at this point include college campus or other facilities, and just this definition, which I just read on line 14 of page 7.
Yeah, correct. That is my intent.
Senator Johnston.
Thank you, Madam Chair. Correct that that's the reference that we're signifying.
Senator Stedman.
Thank you, Madam Chair. If I understand what we're amending here, Senator Johnston, your amendment is being located in the provisions in Title 26, I believe, and the definition of school, Senator Romer, that you're asking about applies to Title 12, Article 43.3. And so and so I believe the answer to your question actually should be no. It's undefined. However, I would just point out for the body that, we already have the Federal Safe and Drug-Free Schools Act. It's already prohibited by federal law. And so I don't really know that this accomplishes anything one way or another. Harmless error.
It's fine. I support it.
Senator Romer.
Yeah, thank you. Thank you, Senator Stedman. But I still think it pretty clearly in the plain language definition of school, this is a common sense amendment, and I support it.
Question is the adoption of floor amendment 170. All those in favor say aye. Aye. Opposed, no. The amendment passes. Mr. McGowan, please read floor amendment 173.
Amendment 173 to House Bill 1284 by Senator Penry, amend Regos Bill, page 64.
Thank you, Madam Chair. I'd move floor amendment 173. This amendment strikes the fee, the sales tax application, 3% sales tax on the product. This bill, unfortunately, has what started off as a bill about regulating marijuana has turned into a bill to help feed our addiction to spending. It, to me, seems inappropriate, crass, and wrong for us to, on the one hand, take money from taxing marijuana use and use it to treat drug treatment. We know that even with this bill, there will be abuses of the system because there are inevitably loopholes and people will find ways to work around it. And this just should not be a revenue bill. And for that reason, I would ask for an aye vote on the amendment.
Senator Romer.